the last, yesterday and today, we talked about some of the gravest outcomes of uh, the failures of Indian democracy. One of them was centered around uh, unbridled hate speech and hate violence targeting Muslim minorities with impunity. We spoke a lot about that. We spoke about the poisoning of the whole social public space. And somewhat with Rahul's presentation and so on, we talked about something else. We also talked about the targeting of voices of conscience and dissent. I think what we are trying to do in this session is to understand there were institutions, there were processes that were designed to prevent this to happen. There were institutions that should have defended Muslim minorities or any minorities when they were suffering hate attacks. There were institutions that should have come into play when voices of people of dissent were being targeted, put in prison without trial, and so on and so forth. So we must recognize that the decline of democracy that we see is enabled by the decline in the institutions that were designed to defend minorities and conscience, like the freedom of religion, the freedom of conscience. And how are these institutions functioning? Why are they failing us? In what ways have they failed us? Ideally, we should have talked about many institutions. We did have Seema quite wonderfully talking to us about one institution, which is the media. We haven't anybody to talk about the civil service and the police, which I think had to play a very significant role. But its collapse, I think, is scale and having been part of the system. I would say, media is closed, judiciary is closed, etc. But the degree of collapse of civil service, the police and civil service, is perhaps the most comprehensive. But we're talking about here in the limited time we have, we're going to talk about the institutional collapse in the context of the judiciary and the election commission. And then we're going to look at one more consequence of this collapse, which is the integrity of the electoral system itself through election bonds. And Anjali will be talking about that. I've been called in to chair three wonderful people, very, very dear friends, but outstanding public service they have done in multiple ways. I first called upon Prashant Bhushan. Prashant Bhushan is arguably India's foremost public interest lawyer, whom everybody who needs to move the court for justice. The first name that comes to your mind and heart is Prashant Bhushan. And Prashant would talk to us about the judiciary. And he's had the courage to call out the judiciary in ways that very few practicing lawyers who go back and stand in front of the same judges is able to do. So Prashant, 20 minutes and the judiciary.
Thank you, Harsh. So good afternoon. I hope that people are still awake after this sumptuous lunch that we were fed on. So for the last day and a half or the last 24 hours, we have heard a great deal about the collapse or virtual collapse of Indian democracy. And this collapse was brought about in many ways by an assault on Article 14 rights, assault on minorities, assault on freedom of speech, assault on liberty, assault on all institutions, regulatory institutions, assault on the, the basic pillars of democracy itself. And in this kind of situation, the judiciary in India had to play a very important role because it is really the judiciary which has been tasked by the Constitution to protect fundamental rights, to protect the rule of law, to ensure that the executive and the legislature function within the bounds of their powers, and to also ensure that other institutions are protected, other institutions like Election Commission, etc. And therefore, in these circumstances, we expected the judiciary to play a very significant role. But unfortunately, that to a very, very large extent did not happen. And we have seen it in many ways, in all kinds of ways. And that is why actually, because it didn't happen and I was virtually forced to make that statement for which I was accused of contempt, where I said when the history of the collapse of democracy is written, the role of the Supreme Court, the role of the judiciary in general, the Supreme Court in particular, and particularly of the last 4 Chief Justices would be underlined in the collapse of democracy. And that's the statement for which I was accused of contempt, and they almost sent me to jail for that. But ultimately, I was let off with a 1 rupee fine. But, so if you look at what happened to Article 21 rights, that is life and liberty. So we have this spectacle during the Modi years. I am talking about the Modi years, 2014 to now. So first we had this Bhima Koregaon case, which in which some of our finest human rights activists in the country have been accused and jailed for the charge of attempting to assassinate the Prime Minister. And that charge is based on some emails supposedly exchanged between the person accused and some other person. And that emails have been proved to have been planted in their computers through this Pegasus software, which was purchased by the Indian government from Israel. And yet, for till now, the arrest happened almost more than 6 years ago. Till now, the trial hasn't even started against these people. And yet, many of them, more than half of them, are still languishing in jail. Only some of them have been released on bail on various stringent conditions so far. But the more than 7 or 8 people accused, there were about 15 people accused in that case. More than half of them are still languishing in jail. And this shows a great failure on the part of the judiciary that it should be evident, whatever the charge may be, even if you say, well, at this stage, we are not going to go into the correctness of this expose, which showed that the emails had been planted, etc. How can you keep somebody in jail without trial, without giving them bail for 7, 8 years? And people who are known to be, who are visibly some of the finest human rights activists in the country, whose work is universally recognized. So this is just one example, but there are many such examples. There are many of the accused in the Delhi riots cases, which also happened almost 5 years or 4.5 years ago, who are still languishing in jail for more than 4 years. People like Umar Khalid. Again, some of the finest activists in this country, all of whose speeches are on video, because every speech that he ever gave was recorded on video. Yet an absurd charge is made against him and many other people that they have tried to incite riots and they have given speeches inciting riots, etc. Clearly provably false allegations on the basis of their own videos, and yet those people have still not been given bail and are languishing in jail. And the situation, yesterday I was discussing with someone that ultimately the cases for their bail, etc., landed up in the Supreme Court, not just Umar Khalid's case, but many other cases of many other people. And they were given to a bench headed by this lady called Bela Trivedi, who used to be the law secretary under the Modi government in Gujarat, and whose views are well known, who has never ever, I mean, she is not the only judge in the Supreme Court of this kind. There have been others also who have never ever in their lives decided a single case against what the Modi government wanted. Bela Trivedi is one of them. Arun Mishra, another infamous man who ultimately had written that judgment sending me to jail for 3 months for contempt. But ultimately the other two judges apparently prevailed upon him and said that, no, you better not do that. And they finally, but that gentleman, he decided any number of very important political cases involving Modi, in favor of Modi, any number of cases giving benefits of 20,000 crores to Adani, and cases, some of them he heard during the summer vacations, totally contrary to the rules of the Supreme Court. And that gentleman has also been rewarded with a post-retirement job. He is the chairman of the National Human Rights Commission in India, where the only thing of note that he has done is to hold a conference of why human rights organizations are the biggest threat to human rights. This is the gentleman. And there are others. There is another gentleman, Hanvilkar, who gave a judgment while dismissing Tista Setalwad's petition, Tista Setalwad and Zakia Jafri's petition regarding investigating the Gujarat riots. While dismissing it, he asked for an FIR to be registered against Tista Setalwad and asked for her persecution. He has given many draconian judgments, making the Prevention of Money Laundering Act even more draconian. And that gentleman has been again rewarded with a post-retirement job of the Lokpal, which is the anti-corruption ombudsman in India. So, Article 21 rights, the Supreme Court essentially failed to protect in those few far between cases where they gave bail occasionally to people. That also happened after these people had remained in jail for years altogether. Article 19 rights. So we have seen the incarceration of journalists, activists, and politicians. Very often on the ground that they have given some speech or said something on which a charge of sedition. Of course, now the Supreme Court has stayed the law of sedition and said that no more cases can be registered for the time being under sedition. But they have registered cases under Unlawful Activities Prevention Act, etc., against people merely for giving speeches. And again, many of those people, including elected chief ministers, have been made to languish in jails for months altogether without being given bail. So even Article 19 rights were not significantly protected by the Supreme Court. They have made some utterances about, on the one hand, we have this situation of people being jailed or people being accused for just exercising their right to free speech. On the other hand, we have the spectacle of the mainstream media continuing a continuous tirade against Muslims, making provocative, hateful remarks against Muslims, which are crimes under the Indian law. But other than sort of occasionally some mild admonishment, etc., nothing significant has been done to these media channels, media organizations, and anchors who have been spewing hate and inciting, and even inciting violence against the minorities in India. Then, of course, there are Article 14 rights. As I said, there are lynchings of Muslims taking place in the streets. Hardly anything is done by way of holding the persons accountable or holding sometimes the lynchings are happening in plain view of the police. The police officers are standing by and watching the lynchings and they do nothing. But nothing significant has been done to even hold those police officers accountable, because of which these kind of things could have been stopped. If some of these police officers had been held accountable, if some of the governments had been held accountable for failing to enforce the law on all this, then this could have been stopped. But what to say of this? In India today, we are seeing this spectacle of what is called bulldozer justice, where somebody is accused. So the police makes an accusation that you spat on a religious procession passing by. That charge is just made, it's not proved. Some FIR is registered. And on the basis of that, the police goes and uses bulldozers to demolish houses of these people. And this is happening in state after state, in UP, in Madhya Pradesh, in many states. Completely against the rule of law. It's bulldozing the rule of law. But the courts have not stepped in to stop that either. On the other hand, in that Ayodhya case, they have allowed, not only legalized, virtually legalized all that vandalism that took place, but handed over the place where the mosque was demolished to the very people who demolished the mosque. The Citizenship Amendment Act was brought, which clearly, it's been 5 years since that act was brought. That act has been challenged. There are more than 200 petitions pending in the Supreme Court challenging that act. But for 5 years, the Supreme Court has not had time to deal with that case. There are sometimes encounters which the police, or sometimes in the gaze of the media, there was the gentleman called Atiq Ahmed. Of course, he was a criminal. He was arrested. He was being transported somewhere. And at some place, when he had just gone out of his vehicle to relieve himself, at that place, he was suddenly accosted by a number of journalists and then one of these people pretending to be a journalist took out a gun and shot him in the gaze of all the media. And again, nothing is done. And clearly that encounter was stage managed by the police and the government. And the chief minister praised that encounter and he said, ki hum to thok denge, that means that I'll kill all these criminals and so on. So there is absolute trampling of the rule of law going on, and yet this is not being stopped by the courts, which is their primary job to ensure. Parliament has been functioning. The Lok Sabha speaker, who is in charge of ensuring the functioning of the Lok Sabha, he doesn't allow the opposition people to speak if he doesn't want to allow them to speak on issues of grave importance. He sometimes blocks their audio or the video. It happened yesterday also when the leader of opposition asked for a discussion on this medical entrance exam, paper leaks, etc. He suspended more than 100 opposition MPs, depleted the opposition MPs' strength by more than 50%. And during that time, without any discussion, very important laws were passed in Parliament by just in the bedlam and a voice vote. So, Parliament has been reduced almost to a joke, and unfortunately, the Supreme Court doesn't do anything to stop that. I would say that these laws, the laws which have been passed, these three criminal laws, are vulnerable. Apart from being vulnerable on their draconian content, they are also vulnerable on the ground that you have passed them in a manner which is totally illegal. You have totally illegally barred or suspended more than half the opposition MPs, and then without discussion, you have passed these laws. I mean, these are matters which the court should have taken note of suo moto, but unfortunately, they have not. The various state governments have been compromised by way of buying off MPs from the opposition parties. If the opposition was heading a state government, some of their MLAs were bought by the BJP, and the government was toppled and another government was formed totally illegally in violation of the Anti-Defection Act, etc. And yet those governments are being allowed to function. Those cases go on, they languish in courts, go back and forth, etc. So there is trampling of our democracy on a very large scale, which also has been allowed to be passed. I'm not saying that the courts have done nothing good. Anjali will talk about the electoral bonds case, where though they gave this judgment after 6 years or 7 years, yet they gave a good judgment, a good strong judgment in the electoral bonds case. But by and large, considering the kind of things that have been happening in India and the critical role that the courts ought to have played, we have seen virtually nothing. So why did this happen? Why has this happened? What happened to the judiciary? So one thing is that when there is a strong fascist government, then a lot of judges who are not very strong internally, they kind of succumb due to fear, and they are willing to do whatever the government wants to do out of fear. This happened during the emergency of 1975 when fundamental rights were suspended, though even at that time, 10 high courts, as many as 10 high courts in the country ruled that at least even during an emergency, a habeas corpus petition was maintainable. But unfortunately, the Supreme Court, the 5 senior judges of the Supreme Court, barring one judge out of them who gave a dissenting judgment, 4 of them gave a judgment saying that during emergency, even a habeas corpus is not maintainable. So effectively, the rule of law itself is suspended during the emergency. So that happened out of fear. And the same kind of fear we have been seeing during the Modi regime, especially during Modi 2. That is after 2019, when the BJP got a brute majority on its own and didn't have to depend on their alliance partners at all. So at that time, we are seeing that many of the judges who are otherwise decent and honest judges, but who are not internally very strong, that they have succumbed to this fear of a fascist government. Then there is this lure of post-retirement jobs. So this Chief Justice Gogoi, who gave that Babri Masjid judgment and who also dismissed a petition filed by Yashwant Sinha, Arun Shourie and myself, seeking an independent investigation into the Rafale aircraft deal scam. he gave a judgment in which he wrote some absolutely ridiculous, grotesque things on the basis of a unsigned note handed over in a sealed cover by the government to the court. Actually, that kind of note ought not to have been taken cognizance of by the court, but he reproduced some of that note in his own judgment, and it stated facts which were totally wrong. It stated that CAG report had been given on this deal when in fact there was no CAG report. And this gentleman who dismissed that case, who was actually, I'll come to that, he has been given a post-retirement job of a member of parliament in the Rajya Sabha. Similarly, this gentleman, Arun Mishra, he has been given National Human Rights Commission. Khanwilkar has been given this Lokpal. So many judges who presided over some very infamous judgments of the Supreme Court have been given post-retirement jobs. So many judges are lured by this post-retirement jobs. Then this government has come out with a new method. Yeah, I'm just finishing it. Yeah. This government has come out with a new method of ensuring that inconvenient or independent-minded judges don't get appointed. The law says that the selection of judges is done by a collegium of 5 senior judges of the Supreme Court. Yet, this government has just refused to notify the appointments of judges selected by the collegium if the government feels that this judge may be inconvenient to it or may be independent. They just refuse to notify. So no Muslims are allowed to get into the Supreme Court now. And nobody who they feel would be independent is allowed to come to the Supreme Court. Actually, this amounts to contempt of court, and the court should take action for contempt against the government for not following the recommendations of the collegium, because all that the government can do is to return the recommendation once. After that, if it is unanimously reiterated, they have to appoint. But even when in at least 12 cases we have seen unanimous reiterations, still no appointments. And the court, unfortunately, doesn't feel strong enough to take action for contempt against the Prime Minister or the Law Minister who have obstructed these appointments. And the last way of managing the judiciary is the most sinister, which is this government has adopted a method of making dossiers on every judge of the Supreme Court or the High Court. Every agency is told that you make any time that a judge is appointed, a dossier is opened on him, and all agencies are told to put out anything, especially anything unsavory that they can discover about that judge or any close relative of his. And if they find anything unsavory, they use that to blackmail that judge into submission. And if that judge happens to be a Chief Justice like Gogoi was, and they had that sexual harassment case against him, then of course they can get virtually anything done from the court, because the Chief Justice plays a very critical role by way of assigning cases to benches. So he can virtually decide the fate of every politically sensitive case by assigning it to an appropriate bench. So if they have the Chief Justice under their control, if they can blackmail the Chief Justice, then they have half the judiciary under their control. So this is what has been done. Now the question is, what can be done about this? Well, we need to get rid of government's role in giving post-retirement jobs to judges. This whole appointment system, in my view, we need a fully independent, full-time body to decide appointments. And after that, once they make the recommendation, the appointment should automatically be made. There should be no question of government issuing any notification after that. Last question is, do we expect the judiciary to change after this 2024 election results? My own view is that at least the first element will go away. That is, to a very large extent, the fear of a strong fascist government which deters some otherwise decent judges from taking giving independent decisions, at least that fear to a substantial extent is likely to go away, in my opinion. And therefore, we will see the judiciary asserting a little more independence after 2024. Thank you very much.
Thank you, Prashant. And as I said, for a serving lawyer who stands before the Supreme Court bench every day, this kind of very courageous truth telling is very special and very that you said what you said. Before Mohsin comes in, I want to recall Rahul's characterization of this period as competitive authoritarianism. Now, the competitive part assumes that at least 3 elections will take place. And then there'll be other elements of authoritarianism. What is troubling is that we are seeing the election commission itself compromised and the judiciary not doing nearly enough to keep it in rein. And that's where what I think in different ways our next 2 speakers will speak about. Mohsin will talk about the election commission as a compromised institution and by implication the Supreme Court as a compromised. Right? Okay, that's right. Oh, I'll need to see. Yeah. Sorry.
I can just sort of whatever is good. Thank you so much, Rahul, Pratik, Matthias. While my slide is getting set up, I'll just start to save time. It's an absolute pleasure to be speaking to all of you. And in many ways, my presentation is a bit of a footnote to Prashant's much broader, capacious take on the state of the Supreme Court, because I sort of take up one element of the way the Supreme Court is compromised in, I hope, in illuminating ways. Sorry to talk as an academic, but also I feel, yesterday Yasmin said that she feels like a historian among political scientists. As you will see from my presentation, I'm definitely a legal academic among political scientists and other scholars. So forgive me for my disciplinary limitations. Now, what I think my primary focus here is, Rahul's comment during his presentation, the notion of free and fair elections. And I agree with him that these elections were not free and fair, even on a spectrum, what Indian state by and large was used to. And in a major way, the reason that compromise happened was because of how the Election Commission acted or enacted. Initially, when I was preparing this presentation, I thought I will just focus on the failures of the Election Commission of India. But there are so many that I thought it would just be a bit of a drab, and it's quite easy to identify the range of problems that happen with the Election Commission. Colleagues have done election monitoring, so I'll not belabor the point, and many of these things have come up. But primarily what I thought was to sort of put broadly the failures of the Election Commission in 3 different buckets. And the aim here is twofold. The first is just to show the range of failures that happened with the regulation of the electoral process during the 2024 election. And the second, indirectly, is also to tell you what kind of work is the Election Commission doing as a constitutional authority, because it is not a straightforward regulatory authority. And that is really important part of my argument, that Election Commission regulates in very subtle, what I call architectural ways, and in ways that are not readily identifiable and amenable to courts coming in and judicial review. So the 3 sort of buckets of failures. The first was, broadly speaking, non-enforcement or prejudice enforcement. So an example of that would be the complete failure of the Election Commission to enforce the Model Code of Conduct, which is a non-statutory entity, among other things, includes a bar on any candidate using religious or caste divisive language or hate speech. These are loose words. And as we know, Narendra Modi consistently used horrific hate speech, not just hate, just subtle hints at it. And the Model Code of Conduct was not enforced against him at all. In fact, the Election Commission sent notices to BJP to send answers, whereas the traditional way in which the Election Commission operates is to ask the candidate who's made a mistake to report an answer, and quite often to prohibit or bar campaigning. The second was a range of cases in which there was non-intervention. There was voter suppression, there was opposition intimidation, there were several seats in which the opposition could not even have a candidate. As one particular case was that of Shyam Rangila. And one of the themes, he's a comic, and he's built a career out of mimicking Narendra Modi, and he wanted to stand against Narendra Modi. And just as as a point, as in the role of humor in resisting these autocratic strong men, there's a reason why his candidature would have been lethal in many ways for a person who won the election by just a very small margin of 1.5 lakh votes. So he was, in rather dubious circumstances, not allowed to register. And then he couldn't contest elections. And the third set of problems were related to non-transparency. The Election Commission refused to have proper press briefings. It had just one really close to the election results, was communicating over Twitter, was not revealing voter data, which created a lot of ambiguity about what was going on in the elections. And the reason why that's complicated, that's important, is because a lot of the problems or in the functioning of the Election Commission are difficult to know because it's such an opaque institution. So to make an academically informed argument that there is bias or there's prejudice or there's discrimination is impossible to know. One example would be in 2019, I tried to collect all the MCC violations, Model Code of Conduct violations from their websites. This time around, nobody could access any complaints or Model Code of Conduct. For an institution that makes such a big deal about enforcing electoral ethics, it is impossible for an ordinary researcher to collect any data on what has been happening with the Model Code of Conduct. So apart from the range of violations, another point is that in each of these things, the Election Commission could have intervened. But the legal grounds of intervention are always very subtle. So for instance, with the non-intervention point, what could the Election Commission have done, constitutionally speaking, when there were arrests of opposition leaders? There's nothing explicitly there under the law. But the understanding in our political culture is, and institutional practices, that Election Commission would step in order to protect the integrity of the election process. That's a very broad constitutional mandate. And that would include potentially, for instance, if I were the Chief Election Commissioner, I would call political parties together to say, you can't possibly be arresting sitting chief ministers in the opposition because that destroys the integrity of the electoral process. And it's not that the Election Commission has not done these things in the past. It has, but it was a complete failure. There are three sets of arguments, time permitting, which I'll try and make. They're overlapped. The first one is an argument which is a bit interpretive in nature. And that is really arising from a larger conversation around democratic erosion and institutional erosion. Because when we talk about erosion, it is both in terms of continuity from the past, but also identifying the new things that have happened. And one of the claims, which I may not get time to talk about in greater detail, is that there are embedded problems in how Election Commission operates. These are old problems, but what is happening in many ways is the old tools in new hands, and those tools being sharpened and weaponized more than ever before. But these are older problems. The second and third diagnostic problems is that in a major way, and here the Supreme Court comes in, and my focus will be primarily on the Supreme Court's interaction with the Election Commission, and as a way to understand how India's political culture broadly has failed securing this institution. And the diagnostic problem is that just as the Supreme Court and other actors in our political culture in India have failed to fully recognize the constitutional significance and constitutional status of the Election Commission. That is reflected in some of the Supreme Court judgments I will talk about. And I think that also opens up a possibility of reform towards the end. The phrase I'll use is the fourth branch, which is often used in comparative constitutional studies to indicate that an institution that is separate from the three identifiable branches. That is what I believe is the constitutional status of the Election Commission. Very quickly about the background, because it's important to note that some of the dilemmas of running the Election Commission are quite baked into the history of the institution itself. Nice of you. But there are two things, perhaps for brevity's sake, that I want to draw out. The first is that there was absolute unanimity among members of the Constituent Assembly that the Election Commission must stand outside the executive. That was a principled agreement in the constitutional framing. And hence the understanding was this is not the judiciary, this is not the legislature, this is not the executive, it is something different. They may not have the words for it at that time. We call that the fourth branch today. The second is the difficulty with identifying the mechanisms of securing this fourth branch. Because there was no existing model at that time. And what eventually the constitutional framers ended up with was the idea that, all right, we are not going to code everything in the constitution. We'll give the parliament the power to make a legislation. The second thing they did was they decided that the election commission should be a permanent institution, and it should be permanent in the office of the chief election commissioner. So when you look at the constitution, it secures the tenure and the service of the chief election commissioner, but allows the government to appoint additional election commissioners. And that's important. I'll come back to it. So we have a permanent institution which does not provide, the constitution does not provide an appointment process. And what has happened subsequently is, until very recently, that the executive was free to decide who the members of the election commission would be. Second, in terms of the operating sort of independence, only the chief election commissioner was protected and not the election commissioners. So there's a long history after that. Some of us may know it. There were different ways in which different governments tried to weaken it. So one parliament never stepped in to make a law. And one example of how other mechanisms were used by previous governments potentially to undermine the independence of the election commission was this T.N. Sessions saga. Because he was an assertive chief election commissioner during the 1990s, the government introduced additional election commissioners. He went to the Supreme Court to make the argument that, well, what you're trying to do really is to undermine my independence because the election commissioners are not constitutionally protected. So you can influence them in order to influence the election commission. That's a longer story. We can go into it in greater detail if there's time later. But what I want to do, again, for brevity's sake, is focus on how these sort of problems of lack of accountability and lack of independence are constantly reproduced in today's time and sharpened and weaponized. And another sort of reason why to do it is, Anjali will talk about the electoral bonds case. And there is this, in my view, there's a sharp distinction between the rhetoric of celebrated judgments in the Supreme Court, and this is one of them, and when actually these kind of judgments are meant to be enforced. And the spirit of this argument is we should also be able to identify how are the different ways in which the Supreme Court is not enforcing the Constitution. Quite often it does so by announcing we have a right to privacy. But when it comes to enforcing the right to privacy, it does not do so. Another mechanism in which the Supreme Court today is not enforcing the Constitution is by sitting on cases for years and years. So delay tactics again. And I just want to take up this particular case to do it. Now, in 2003, the Supreme Court in the Anup Barnwal case, and it was a bit funny because almost all the cases I'll talk about are what Prashant and other friends and colleagues have filed. So in a way, it'd be wonderful to hear from you. All the modern, at least aspirational jurisprudence of the Election Commission is Prashant, Bhushan and team, basically. So it's a pleasure to be speaking next to him. So what did this court say? The petitioners went to the Supreme Court to basically argue that the Election Commission the appointment process is not secure. It's not an independent institution because the executive is getting a free pass. There's no parliamentary law which creates a system in which that independence can be maintained. Supreme Court agreed. And Supreme Court then, in a celebrated judgment, set up a selection committee of 3 people, the Prime Minister, the leader of the opposition, and the Chief Justice of India. And there were broadly 3 reasons in my reading that the court did it. The first was the court said there's a legal gap or a vacuum in law. There's no parliamentary law. And therefore, we are going to step in. It's an important argument. I'll come back to it. The second is that, well, Supreme Court can step in, that even if Parliament was meant to do it, India's separation of powers is not that significant, or at least it's quite flexible, and therefore we can balance democratic republicanism as a way to sort of step in and create this sort of process. And the third is that ECI, Election Commission, is really significant. It has such broad range of powers, and therefore we are justified. In hindsight, I feel that each of these reasons were deeply flawed, and in my view, represent the failure of the Supreme Court to recognize the constitutional status of the Election Commission. Why? The first is that the idea of the legal vacuum or legal gap is a misnomer, because the Constitution does not demand that Parliament must make a law. So there's no gap. It authorizes Parliament to make a law. And this may seem like a lawyerly point, but it becomes significant when I go to the next point. The second is, again, the issue is less about whether separation of powers is flexible. The question is, where does the Election Commission fit in the constitutional scheme? And the Supreme Court failed to do it. As in, my proposal would have been that the Supreme Court should have accepted or appreciated that Election Commission is not an odd feature that is despite separation of powers, that it is one of the branches next to the Supreme Court, as significant as the Supreme Court in terms of constitutional significance. And the third is, go back to the first slide, which is the range of powers and the different ways in which the Election Commission maintains integrity. I'll give you an example. For instance, the Election Commission regulates the electoral process by creating schedules of elections, 5 phases. There is no way that those kind of decisions are easily amenable to courts reviewing those decisions. That's one of the reasons why we constantly argue that 5 phases was unfair. How did you design these schedules? And they do affect election outcomes. But it's very difficult for Supreme Court to step in. The realization should have started there, that the Supreme Court can't step in. There must be other mechanisms of ensuring independence and transparency. In that manner, this is why you need to recognize the constitutional status of the Election Commission. So in summary of it, in my view, the Supreme Court, despite the celebrated character of this judgment, failed to identify the most significant constitutional questions. What are the stakes of that? Stakes of that is that very soon, Modi government undermined this judgment. Within months, a new legislation was created which removed the Chief Justice from the selection committee and composed this selection committee of the Prime Minister, leader of the opposition, and a person in the cabinet nominated by the Prime Minister. So guess who would that be? And therefore reintroduced executive dominance in this process. And to be cherry on the top, this whole business around Arun Goyal as the election commissioner also evolved. So the short summary of it is that he was a bureaucrat, he took early retirement, then suddenly was appointed as the election commissioner. And right before elections, he suddenly, in suspicious circumstances, resigns, and a new person is introduced. And the process in this election committee under the statute is absolutely not transparent and opaque, which raises serious concerns about who is this new person who was appointed. Prashant went back to the Supreme Court. What did the Supreme Court say? Supreme Court, among other things, basically said, now there's no legal vacuum. Parliament has stepped in, and now there is a law, and therefore the basis of the Bharadwaj judgment doesn't exist anymore. And in addition, as sort of came up in some of the conversations yesterday, when it was pointed out that elections are coming up, this is a significant decision, the court said, yeah, but we can't take this decision because it may impact the election results, and therefore it'd be inappropriate. So suddenly the court has discovered this judicial restraint quite conveniently. But these are different judges. In the previous case, it was Justice Joseph, and this one is Justice Datta, and maybe Prashant and the rest of them can tell us more about these judges. Let me just sort of conclude very quickly. Maybe I'm going to leave out the business of electoral bonds because it will be covered later. And I think a similar story is happening in the VVPAT case. Because of lack of time, I won't do it. But I'll just end with one thing in terms of sort of some, in the spirit of constructive suggestions, if those are possible. Purely legally speaking, obviously the process of appointments is absolutely flawed, and that goes without saying. But I think there's another thing which is often not talked about, which is the operational transparency of the Election Commission as a body. And we do not often talk about how Parliament should become a site for enforcing just basic transparency of the Election Commission. An Election Commission is one of the most opaque institutions in the country. So if Parliament has become slightly stronger with more teeth, then that is perhaps a much more actionable agenda of trying to get the election commissioners to speak or to present in front of Parliament, committees somehow. I haven't looked into the proprieties of that, but that is perhaps one of the most significant things because many of the things that the Election Commission does are often very subtle and under the radar and highly consequential. Yeah, thank you.
Friends would agree that, among Mohsin, many merits have known for many years, the clarity of his legal analysis was very valuable in understanding. Anjali, who is foremost among our very active human rights activists today, and has been fighting these battles along with Prashant and a few others, decided that she would take this story into greater depth, particularly the question of electoral bonds. How the failure of democracy and its, at least the integrity of its competitive process, how that has now been so badly eroded with the complicity of the other institutions.
Thank you, Harsh. So, like Harsh said, I think, am I loud enough? Okay. Like Harsh said, the story of electoral bonds is really the story of institutional capture, collapse at many levels. And I'm going to hopefully walk you through some of those within the next 20 minutes. So before I start, let me just very briefly tell you, give you a little bit of the background of political party funding. So traditionally, the political system in India has been very averse and hostile towards transparency in political party funding. The way in which our political parties were funded in the past was basically through either the banking channel or through cash, and largely through cash. And many of them only through cash. And then there were two things. One would be that most of that cash would be undeclared. They would not even bring it on their books. And there were some loopholes in the laws, like the Income Tax Act or the Representation of Peoples Act, which basically stipulated that any contribution less than 10,000 rupees, the political party needn't say who gave that money. The source of that income did not have to be declared by the political party. So there was a very strong perception that there was quid pro quo. Political party funding was widely recognized as the fountainhead of corruption in India. So there was a very strong demand for greater transparency in political party funding. And when the Bharatiya Janata Party came to power on the plank of anti-corruption, one of the things that they promised was that they will bring greater transparency in political party funding. In 2017, the BJP introduced the electoral bonds, and basically the then finance minister, Mr. Arun Jaitley, introduced it in the floor of the House, saying that this is a measure to enhance transparency and to fight black money in the system. But what was this scheme? What are these electoral bonds? Basically, through the Finance Act of 2017, 4 amendments were made to laws. These were very regressive amendments that were brought to 4 important laws, including the Representation of Peoples Act, the RBI Act, the Income Tax Act, the Companies Act. These were all amended, but through the Finance Act. And those who follow the parliamentary system in India, we know that the BJP had a brute majority in the lower house. And by bringing it through the money bill route, through the Finance Act, there was really no scope for discussion or debate in Parliament. And when I talk about institutional capture, I talk about compromising of institutions. I think the way the Parliament has been compromised in the last 10 years, this really does in many ways bear testimony to that. The electoral bonds that were finally brought in through the electoral bond scheme, which was brought in 2018, essentially opened the floodgates of anonymous, unlimited funding of political parties. So all the amendments that were brought to the laws were to say that there will be no information provided to citizens or to regulators about who is funding political parties through electoral bonds, because the names of donors and the parties to whom they were donating those electoral bonds would be completely anonymized. And what we saw, therefore, was a complete consolidation of the role of big money in our political system. Because what the electoral bonds did was that they did not stop the flow of cash into political parties. That continued. which also is borne out by the fact that in 2019 elections and again in the 2024 elections, there have been record seizures of cash with the political parties. So cash kept flowing into political parties, but even the money that was coming through the banking channels, which was earlier at least open for scrutiny to the regulators, information was there with the citizens, was also put in the black hole. And this essentially was extremely dangerous in a country which is grappling with crony capitalism and which is seeing the emergence of a very, very strong emergence of an oligarchy. So we have seen that there are a handful of capitalists who today own a large part of the wealth of India, who own most of the mainstream media in India, which is used so much for propaganda. And the consolidation of big money in electoral politics, in the political system through electoral bonds was seen to be widely a very, very dangerous trend. It wasn't just people like us. It was also some of the institutions of the government itself or the state itself who were saying this. We filed right to information applications, which showed to us that the Reserve Bank of India, the Election Commission of India repeatedly wrote to the Finance Ministry saying, don't do this. They said that this will encourage black money, this will encourage money laundering, this will encourage the setting up of shell companies, and there will be interference from everywhere, including foreign spaces, into our electoral system. This will be very, very dangerous. The Election Commission of India said that as a regulator, even we wouldn't know, because those were the kind of amendments that were brought in, that even we would not know whether the political parties are being funded legally or not. There will be no way for us to check. Despite all of that, and our RTI responses also showed that the government not only did not hold any public consultation, even political parties, there was no sharing of the draft of the electoral bond scheme where it was brought in. There were political parties that were writing and saying, okay, you're bringing in this scheme, at least give us a copy of the draft. Even that was denied. So it was in this kind of secrecy that electoral bond scheme was brought in. And of course, a petition was filed in 2017, and a batch of petitions were filed against the amendments that were made to the 4 laws and also to the electoral bond scheme itself. In the Supreme Court, this petition was filed. I think the only thing that languishes as long as political prisoners, the cases in the Supreme Court are these kind of political cases. So we had a very, very seminal judgment in 2024 from the Supreme Court banning electoral bonds, but it was after a wait of at least 7 long years. And that basically means we went into elections, a set of round of general elections in 2019, and then again in 2024, because the judgment came just a few weeks before the 2024 elections, when the coffers of the parties were full using the electoral bonds. All state elections in that period happened with the electoral bonds funding political parties. Finally, the Supreme Court, of course, we celebrate the judgment, said that electoral bonds are completely unconstitutional. They violate Article 19(1)(a) of the Constitution, which basically is free speech and expression. They violate voters' right to information. A voter can't cast. Oh, yes, very dramatic. A voter can't cast an informed vote if they don't know when they go to cast their vote who they're voting for, who that political party has been funded by, and therefore is going to work for. So the court clearly talked about quid pro quo, used the term clientelism, where the court said that in the absence of transparency, when big corporates are funding political parties, especially the parties in power, they're clearly not doing it for a public interest. They are doing it because they want these parties when they form the government to work for them, to make policies for them, to make laws for them, and to give contracts to them, even if it's not in public interest. And in any case, I think this was something that we had all been seeing. The farmer protests, when the question the farmers were asking was, for whom are you making these laws? These are clearly anti-poor, anti-farmer, anti-people laws. Why are you making them for these few capitalists? I think the answers to many of these things did get revealed when we had the information. So the Supreme Court struck down the electoral bonds, said that unconstitutional, struck down the amendments that were made to the 4 laws while bringing in the electoral bonds. And the Supreme Court also said that retrospectively, from April 2019, all bonds that were bought and were redeemed, information about them has to be put in the public domain. Now, this was clearly one step more than what I think most of us expected. But this was a very welcome decision. But then we saw one of our largest financial institutions do the kind of shenanigans that made many of us hang our heads in shame, where the SBI, the State Bank of India, on being told by the Supreme Court that you have to do it within 3 weeks, came back to the court and said in a very brazen move that it'll take us a long time. And this is the largest bank in India. Take us a long time only after the election results are out. So they basically gave a date which was post-election results. The court, of course, sort of decided to not deal with it in a lenient manner and said, you have to do it. And within 24 hours, the bank produced all the information when the court threatened them. Very briefly, I don't know how much time I have left. 5 minutes. What the data reveals in terms of quid pro quo, I think is very, very concerning. Concerning at so many levels, for all of us who are concerned about the health of our democracy. It shows the kind of quid pro quo that all of us suspected was very, very clearly happening. So we have situations where, of course, one thing that it confirmed was the biggest beneficiary of electoral bonds was the ruling BJP. So nearly 50% of the funds that were coming in were to the Bharatiya Janata Party. It revealed one of the largest scams in India, because what we are seeing is that companies have been awarded large contracts in very close proximity of their buying electoral bonds and donating them to the ruling party. So we have an infrastructure company. I'm not going to name any because it's, all of this is in the public domain. There is an infrastructure company which, for example, gave 140 crore rupees in electoral bonds to the BJP and got a contract worth 14,000 crores within a month. So although the electoral bonds, the quantum of electoral bonds itself is 16,500 crores, which is about 165 billion rupees, the amount of corruption that we are potentially looking at is many, many times more. So 140 crores is given and a contract of 14,000 crore rupees is obtained. So, that's the kind of scale and magnitude and multiplier that we are looking at if we talk of the scam itself. We've seen how policies have been so clearly made in favor of those who gave electoral bonds, money through electoral bonds to the ruling party. So, for example, the spectrum allocation, many of you would remember the 2G case where the Supreme Court then had held that it has to be done in a competitive way, spectrum allocation in the country. Money was given by one of the telecom companies, and that whole thing was changed. In fact, a bill was brought into Parliament at a time when 142 members of Parliament were suspended. The telecom bill was passed to favor that company and to say that administratively, without a competitive bidding, this allocation can be made. And the government has also approached the Supreme Court now to say, please reverse your decision or reconsider your decision. I think that has thankfully been dismissed. But we've seen how policies have been clearly impacted. Regulatory inaction. We saw how there were pharma companies whose medicines were shown to be of substandard quality, but continued to be sold without any action by the drug regulator because the ruling party in Gujarat, this company, for example, was based in Gujarat, the ruling party the BJP got money through electoral bonds. What it has also shown, and I'm going to finish with this instance, Harsh, is the weaponization of many agencies, how it has been enabled through these bonds. So we all know, I don't have to talk about the ED and the CBI and the role of these institutions, but what the data on electoral bonds is showing is how they potentially enabled extortion. So there are companies whose cases are being looked into, investigated by these organizations, and they are giving large sums of money to the BJP, which is the ruling party at the center and controls these organizations, and how their cases are going into cold storage, what we've really got to know as the washing machine phenomenon. That's also at work here. And of course, I mean, when we are talking about impact of crony capitalism, this kind of money and the collapse of institutions on the electoral process, what Rahul also mentioned, we know that two sitting chief ministers of two states in our country were put behind bars just before elections. One of them, in the Delhi case, where the liquor excise policy is there, the main approver happens to be a person called Sarat Chandra Reddy, who was arrested by the Enforcement Directorate. And within 5 days of his arrest, his company, Aurobindo Pharma, gave 5 crore rupees to the BJP through electoral bonds. He applied for bail. His bail application came up in May 2023. And the ED, which sits and refuses to budge and opposes every single bail application of any political activist, said, we don't have a problem with his bail. And on medical grounds, he said, I have a pain in my lower back. So he got bail. He came out, became approver, and was pardoned, and his company bought another 50 crore rupees worth of electoral bonds and gave to the ruling Bharatiya Janata Party. So what we are seeing is how the CBI, ED, their role is emerging through some of this. And money laundering, there's very clear evidence of how loss-making, seriously loss-making companies have given money to through electoral bonds to political parties, 75% of it to the BJP. So there is a huge question of money laundering and through shell companies that's involved here as well. So I'll just end by saying that the Finance Minister of India, before elections, of course, said that if we come back for a third term, we'll bring back the electoral bonds. The Prime Minister said that everyone who opposed electoral bonds will regret it. So we heard all of this, and today we are back. Prashant has taken the case back to the Supreme Court because we know that there's no point asking the CBI or the ED, who themselves seem to be involved, to investigate into this very large scam. So if the accused in this have to be brought to book, if there has to be justice, there has to be an independent investigation into this matter. The demand is to set up an independent court-monitored SIT to look into this case. And I think the test of what Prashant said, that we'll see how this verdict impacts the functioning of the judiciary, will also be tested by how the judiciary now responds to this particular case. Thank you very much.
Thank you, Anjali, for this completely brilliant, deeply worrying presentation of what probably might emerge as the biggest corruption scandal that India has seen since independence. This is what it masks. And that mask is sort of slightly fallen, but a great deal more needs to be if democracy is to assert itself. The good news is that your coffee break is cancelled. And therefore we have a few minutes before the next session. Um, I'm sure there'll be a lot of questions. I just wanted to sort of talk about affirmative action. So we'll first ask women. Second, we'll ask people who've not asked a question before, and then we'll ask the others. Okay. So, okay, women first. Anyone wants to ask a question? John, you don't qualify. You don't qualify on both counts. Yes, yes, ma'am.
I'm just thinking, if these brilliant papers, very wonderfully explained, if the really even will work in a classroom, people will understand what we are all saying. But if a normal Muslim woman walked into this thing and just listened to all of this, they would think, my God, the system is completely, totally failed. Forget who's the next prime minister and how they're going to get there with it, Latin American presidential system or American presidential system, whatever, changing all of that. But who is going to speak for me? Yesterday, Aman talked about all these cases pending for citizenship. There are lots of women we have meeting back in Assam, widows, destitute women whose cases of the citizenship is in question, right? So if this whole tradition is just absolutely collapsed, where do we go? Where do we, even vulnerable women, forget Hindu, Muslim, whatever, women, where can they go when an entire system has collapsed? We don't care who's the prime minister. We don't care anymore. We just want justice. If the whole system of justice itself has not functioned, as a whole, in the whole, we don't get it, right? The husbands beat us up, patriarch. So where else do we get this?
Yeah. So I think that's a very significant reminder that in the end, we're talking about, Gandhiji said, when you're in confusion, think of the most vulnerable person you know. And then what does all this mean to that person? And I think it's terrifying. I mean, it's utterly terrifying even for us with all our social capital. Person who doesn't have this social capital, how are they going to expect any justice from a state that has been so destroyed? Seema, please.
So I just want to, I've been thinking about this for some time now. I'm trying to bridge Prashant and Anjali's presentation. What prompted the Supreme Court to give such a brilliant electoral bond suddenly on the 15th of February? What happened? We switched off and said, when it all happens and we wake up. And he was stunned. So, any thoughts on that?
The nightmare suddenly ended.
Can I add?
Yes,
Just add to
yes, please.
the ADR, how much was it helping to, get this onto the table and the push that they were making? What did you find?
Okay, so this is the first round, and quick responses for three and then we'll begin. Yeah, Prashant, would you like to start?
So where do we go? Where do Muslim women go? And where do Muslim people go? So, firstly, I mean, I presented a very bleak picture of the judiciary. It's probably not all that bleak. There are still a significant, I keep saying this, that 1/3 of the judges on the Supreme Court are good, 1/3 are bad, and 1/3 are so-so. So, there are still some judges of the Supreme Court from whom you can get justice. But in the sort of larger scheme of things, it appears to be very little and far between. However, after this 2024 verdict, I expect, I hope and I expect that that 1/3 who were okay in between, they will also move up and become good. So we will have, the bad will, of course, people like Bela Trivedi will remain. But there are those who are in the middle and who are not finding the courage to speak out against the government. Hopefully now find the courage. But still, I mean, the judiciary situation is pretty bleak, unfortunately, and on the whole, it will probably continue to be bleak. That's not just because of the collapse of its independence. It's also because of the general collapse of the judiciary where cases don't get heard, where you have so many incompetent and now, of course, many sacrificed judges, etc. It's a big problem. So now, Seema, you said, why did the Supreme Court give this judgment? So my theory is, Chandrachud was facing a lot of criticism after that Adani judgment and some other judgments, etc. And that other Gyan Vapi mosque, he didn't stop that case. Even I became very strident in my criticism of Chandrachud, and many other people who were earlier gaga about him also became very critical. Chandrachud is very legacy minded, image conscious, legacy minded. And therefore he felt that he is going to lose everything, his image, his legacy, everything, and he had to do something. So he gave this electoral bond judgment. Now, but he went one step further by forcing them to reveal that was the critical thing, forcing the State Bank to reveal the names of the people who gave the bonds. What I feel is, my assessment is, he received so much praise after the first that kind of encouraged him to take another step. That's my assessment.
Okay. I'm just anxious about what the Muslim movement will do with the source of judges. Let's leave that with
Just to add on, I think I agree with Prashant's political assessment, right? And I think it's just about how we frame conversations around the Supreme. I think one of the great expressions of institutional erosion of the Supreme Court is we can't talk about something about the Supreme. That is a ridiculous framing of what is it. We can talk about certain judges at certain points of time because judgments are given and lawyers know that and we have tradition. But here we have a Supreme Court where two judges delivering a judgment on the same day on the same issue will say something completely different. And that will not be based on their different legal acts, but because of how different ways they are compromised or their predilections or their ambitions or their legacy. Right? But to add to perhaps another dimension, I'm speculating here. I think timing is also of the essence. Why after 7 years now? What was happening in those 7 years? Basically, what was happening in those 7 years was that the Supreme Court and the election, this includes certain judges and the Election Commission, was relying on each other to delay it. Because the initial interim orders, basically, what the Supreme Court said was, give all the data to Election Commission has everything sealed up. Right? So there is this real nice camaraderie happening between compromised judges or weak judges and compromised election commissions. And then at a certain convenient point, when an issue can't be adequately politicized and brought to public notice, that certain judgments are given for legacy's sake. So I am not optimistic about this. I will not be surprised that very soon if it's another Justice Datta or another of Prashant's friends who delivers a follow-up order, it will be completely undermined on procedural grounds or something or delays. So I think I have absolutely nothing to tell.
So I mean, my response is that to your question is that I don't think ever a Muslim woman or anyone for that matter has felt very reassured that they immediately get justice if they're facing oppression or injustice. But I think things have become much worse in the recent times. I work in the slum communities. I remember in one of the meetings there was an elderly couple, Muslim couple, who came for the meeting, and they said that our daughter got admission to the law university, the law faculty in the Delhi University, but we are not planning to send her. So when we asked, why would you not do that? He said, I drive an auto, and you know the community I belong to. So he said, if something happens to her, who has our back? And I think that this kind of understanding is something that has permeated and is very widely in people's thoughts and in the act, and therefore determines the actions that they take in their lives. I've seen how in all the campaigns, all the movements, how women have taken center stage, whether it was the right to food, whether it's against mining, how women go forward.
And CA.
And the CA, of course, and you know, how, and today if you talk to people and you know, you say we are doing a protest, you have to come out, they'll say, now they're not going to just detain us and let us go, they're going to be serious charges against us. And then when they see the Supreme Court dismissing the challenge to the 3 criminal laws that have been brought in recently, which in many ways will make an act of protest, just blocking a road, a criminal act, an act of terror, I think it really sends out a very strong message to people, the marginalized, especially the women. So,
And Yasmin, I can't stop myself from giving you an actual literal answer. When we had taken with Prashant a petition about the detention centers in Assam, and they're completely unconstitutional. You're locking up people for life without any chance of coming out. Justice Gogoi actually said, why are there just 1,000 people in the detention centers? Why aren't there 50,000? You know, and it devastated me because I said, I've gone there and I'm going to make life. I mean, the people were terrified, telling me from the ground that worried now you're going to pick up more people. So the only response that I could have was I filed a petition saying to Justice Gogoi that you have exposed extreme bias and therefore I want you to recuse yourself from this petition. Of course, he was so furious and I went on, and for 45 minutes I thought it was, and the only lawyer who was willing to stand next to me was my daughter, and we went on. He said, now you argue. And I basically said, when I came to the highest court of this land, I was expecting justice, and true justice is always tempered with compassion. And what your response displayed was a spectacular absence of compassion. And therefore, you have to recuse yourself. He was so angry at the end of it. He said, and I thought I was just on my way to prison. He said, there's no question of me recusing myself from this petition. I recuse you from this petition, which doesn't exist in law. You cannot appear before me. You know, that's that Muslim woman and what she's thinking. Just the second one was people who haven't asked questions before. Yeah, I think yes. 1, 2, 3. Yeah.
Maybe just following your conversation, as you said that there are many Muslim communities who are facing community but longer. Actually, is there any social movement from Muslim communities? Because what I have observed there, there are so many Hindus who are
Facing injustice.
yeah, but is there social movement or something from Muslim communities as well? Maybe young people, young generation want to involve in social.
Good question. I'm tempted to answer, but I'll leave it to my friends. Yes.
Hi, everyone. My question is to Mr. Prashant. You mentioned about the need for judges to be strong-willed. I want to know, can the law do something about it, or create an environment where the incentives that they currently get, like the post-retirement, etc., can be shut down? And the second question is, I mean, it's more of a comment. I just want to know if the judges can't see that the lives of millions of people are actually affected by their judgments, and how can the individual incentives that they foresee that they get can even be comparable to actually the effects of their bad judgments that they give?
I think it's a lovely question. I'll bring in 2 veterans as well, and then we can go. John and then Dieter. Okay.
I just really want to ask the question, is it all a matter of the character of the judges? Are there not serious problems with the laws themselves? I was sort of struck by the fact that a law like the UAPA, which gives just so much space to the regime to do pretty much what it wants to do, and don't these problems actually go all the way back to the very beginning? Perhaps I'm sort of too obsessed, with all the debates over what became Article 21 and the decision not to make the right to life and liberty subject to due process of law. And then what happened in consequence of that, the passage of what became Article 22, which, some of the cynics would say gives Indian citizens, unusually in a fundamental rights of the Constitution, the right to be detained by the state without, right to trial or bail for extended periods. I mean, there are, it seems to me, very serious sort of problems in the law itself. And in the sense there is too much depends on the character and the integrity and the courage of those few people.
Yeah, thank you. I think these were both complementary questions that will come. Gaiter and Manisha. And yeah, please, first, please. Please.
So in regard of the topic of the future of democracy, so I would be interested in, we see these days a lot of institutions have a pro-government bias, but now with this election result, do you think this will change a little bit? Because I think also civil servants will have recognized that maybe there's not only one way where the country is heading to, and this impact it could have, I would be interested in.
Yeah, very, very important question, Director. Money, and then I think we'll have to end because, yeah.
Thank you for the presentations. By listening, I had a vision. The combined informal committee from judges of the Supreme Court and lawyers go to Washington, the colleagues of the Supreme Court, to inform them about the electoral bond, because we have the so-called PACS in the United States, the Political Action Committee. They're exactly so, but with my understanding, exactly the same mechanism which has been stopped by the Supreme Court. The daily is now in action. So this is, would be a nice vision that also the Supreme Court in Washington follows the decision of the colleagues of daily. So crony capitalism and internationalism are two sides of one coin.
One coin.
The electoral bonds have been cancelled, but they are thinking about alternative ways of financing in an informal way. Maybe what kind of ideas they have, so that crony capitalism can still go on supporting the middle, etc. So my questions are: first, RSS was not taking part in this electoral bonds. What is the financial basis of RSS? Second question: you name the Indian government as a fascist government, and surely we can differ between a fascist ideology, a fascist government, and a fascist political system. And I think not only because we're in Germany, the term fascist is a very sincere term. And so I'm just asking you, what is your definition, or you are differ between the fascist government, the fascist system, and the fascist ideology. So just how you are using the term of the fascism. Thank you.
I'll absolutely have to insist that Manishankarji's is the last question, and then we'll have a last set of responses.
My question is to you found final satisfaction in a Supreme Court supervised SIT. But we had the example of the Supreme Court supervised SIT completely exonerating Narendra Modi for the pogrom that took place on the Bhatt and elsewhere in Gujarat. And the officer, the IPS officer concerned, who was in fact my batchmate, was rewarded with an ambassadorship to Cyprus. The only and the irony that was missed was that this was the posting of half a man to half the country.
Okay, wonderful. So Prashant, Mohsin, and
For character of judges, whether it can be improved by law or is there not a problem with the law. So to some extent, if you make the selection process of judges more robust, more independent and more transparent, that will probably help in getting judges with, getting us judges with better character, more strength, more independent mind. Today, what is happening is that even earlier the government used to select, that had its own problems. Then the court said that 5 senior judges will select. Now, here there is no transparency, no method, no system, with the result that there is a lot of nepotism, etc. And with the result that you still get a lot of judges through this system, even assuming that the Modi government doesn't stall the appointment of independent judges. They are not recommending only independent judges, they are recommending a lot of judges on the basis of nepotism, etc. So what we need is a system, full-time body, broad-based, completely independent of the government, and which functions transparent, and after laying down a criteria for selection, that will probably ensure more. Of course, nothing can ensure that only very robustly independent judges will get selected, but still that will make a better system. Now, there is a problem with these laws like UFPA, etc. But the judges could have struck them down. We have challenged it. In my view, the provisions of UFPA, we had challenged 2 provisions. One was the definition of unlawful activity in the UFPA law, which was similar to the definition of sedition.
Yeah.
Except for the word government, here it said state. Any creating any disaffection against the state, to my mind, just creating disaffection against the state cannot be an unlawful or terrorist activity, etc. So the Supreme Court, if there were judges of great strength, they should have struck down and then the draconian provision for bail, that you can't give bail unless you record a finding that there is no case against the accused. How can you record a finding without even a trial? So, in my view, both these provisions are unconstitutional. There may be other unconstitutional provisions in this UAPA also. They should have struck them down. But the case was sent before this same lady, Bela Trivedi, and we had to withdraw all those petitions because we knew that the conclusion was foregone with this lady being there. So, there is a problem with the laws, but judges with strength and character should be able to strike down these laws. Any of this, because we have a constitution and Article 21 has been very, very liberally and broadly interpreted by the Supreme Court. And if they want, they can certainly strike down these provisions, the draconian provisions of these. Okay.
Mohsin.
Just to do 2 quick responses. On the questions of text itself, and Article 22 and other things. I don't think text matters that much. Obviously, says the motivation, the context in which actually speaking, right? Because text can be interpreted in multiple ways, and there are always responses. I think a harder question to ask is what is the institutional culture in which these people are operating, and what are their own individuals? So it's like a standard sociological take in judgments. A good example would be quite comparable is looking at the daily cases in the CA telephone cases, where women, basically the same set of charges, but it's one highlighted with the same name, it's not going to get it. And whereas people may get paid, and they're literally the same judge who's doing the same bench for them. And I think it just tells us volumes about what is the culture of suspicion, what is the problem of minoritization, how the names matter, what are the different kinds of threats that these judges face, and also their own prejudices. So those would be the relevant factors, I suppose, to understand what these judges are doing, rather than piece of paper, right? Because that can go on. And very quickly on the effect of the election results specifically on the CI itself, I am not optimistic. I can't look into the future, but I don't suppose without reforms of two kinds of introducing public scrutiny, in similar ways as the Supreme Court, introducing mechanisms of public scrutiny in all affairs of the election commission, in its operation, and second, the appointment process. Unless those two are not reformed, I doubt whether this election is up. So this is a long-term battle.
Anjali.
I'm sure Harsh will add to your question, but let me tell you that in the last 5 years, which have seen the worst of this regime in many ways, the two movements that really rattled the government were the anti-CA protests, where women took center stage, Muslim women especially, and the farmers' movement. So I think it's undeniable that there are very strong leaders within the Muslim community, women, and who have sort of come forward, and they continue to be there, but working under very difficult circumstances. There is so much backlash, there's so much attack. We've seen everything that has happened after the anti-CA protests took place, the Shaheen Bagh and what we call the Shaheen Bagh protests, but it's there. Mr. Iyer, the question that you asked is a difficult question to answer. I think it is ironic that after all of us talking about the problems with the judiciary, what we are doing is really again going back and saying, set up an SIT, a court-monitored SIT to look into this. I mean, the question really is that, is it not really ironic that the Lokpal, which was set up after such a strong people's movement with so much sort of hope that now this will take care of big ticket corruption, has not even said a word on all the scam that has come out through the electoral bonds. Are we hopeful what will happen through the Supreme Court monitored SIT? I don't know. But in a democracy, finally, when you see there is injustice, when you see there is corruption, you do have to go back to institutions. And I think that what we are simply saying is that we don't want this to be taken up by a compromised Lokpal, because we know how you talked about the appointment process. I think one of our biggest sort of disillusionments has been what is the best appointments committee. I mean, with the Lokpal, we thought we really cracked it, where there was these 5 people, the Prime Minister, Leader of Opposition, there was the Speaker, there was an eminent jurist, and the Chief Justice of India. And there was no Leader of Opposition for the last 10 years. So basically, a committee with predominantly government functionaries have been appointing the Lokpal, and we know who the current Lokpal chief is, Justice Khanvilkar. So we are saying, don't send it to the Lokpal, don't send it to the CBI and the ED, who are so clearly involved themselves. Their role is so dubious in the electoral bond scam. So we've gone back to the Supreme Court to say that let there be a court-monitored SIT which looks into this. And of course, I hope that there will be strong public monitoring at every stage of how this proceeds. But the big question is, will this even be taken up, and will there even be an SIT set up?
So friends, just quick response. With all the injustice against Muslims, yes, there are Muslim organizations, but it isn't the duty only of Muslims to respond. There are many of us who feel that it is our collective responsibility. And I wouldn't like to see in India when if Muslims are attacked, then Muslims have to defend. If Dalits are attacked, then Dalits have to defend. We need to stand together. So I want to say that. And on this question of character versus institution, I think, when we do a history of these 10 years and how institutions collapse, Mr. Modi has actually found, I think, the key. He destroys every institution by the kind of person he appoints to it. Just that. He doesn't have to change anything else. And if you just look systematically, every single, you have the election commission, you have each of these, the Lokpal, you have the NHRC, you have each of these institutions, and each of them are destroyed to nothing because of the people that are being appointed to it. And I think that we'll have to, as a society, sit down and find some solution. How do we secure these institutions by securing the selection process, which allows the possibility, the probability of people of character to come to those positions. I don't think there's any shortcut. And when we are in the midst of a civilizational crisis, there is a moral crisis that reflects on the media, on the judiciary, on the civil services, on all of us. So I'll take here, and in the spirit of competitive authoritarianism, I must hand over to Rahul. Please, thank you.